Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. Good morning, everybody. Good morning, good afternoon, good evening, wherever you are. I hope you are having a good start to your week. So this is now Tuesday. I just missed Mean Girls Day. October 3rd is Mean Girls Day. If you've seen the movie, you know the day that Aaron Samuels asked her what day it is. She told him it's October 3rd. So I wish that I would have had a live stream yesterday, but I didn't. Anyway, so let me first say hello to some folks in the chat. Diane Thompson, hello from Kansas. Ali Mazaros, good morning, Alita. Good morning. Patty G, Jersey girl. Hello, Alita. Hello. Back to you. Terry McGee from West Virginia. Patty G, Jersey girl, came over with Eric. That's awesome. Andy, the game maker. Today is October 4th. Thanks for the super chat, brother. Very, very kind of you. Yeah, super happy to see all of you here. We got a bunch of people in the chat, and I have a wonderful new guest today. So I've got, for the first time ever on this channel, I have Steve from Southern Law. And Steve, why don't you tell us a little bit about yourself?
Well, good morning, or whatever, like you said, wherever people are watching from. So I'm an attorney in North Carolina, and have been talking about this Manson case for a while, which is not what I intended to do, but I got absorbed into the Depp case like a lot of people. And when the Manson case came up, I read it and I thought, wait a minute, this isn't exactly like the Depp case. And that's what first got my interest in it, where his attorney's strategy in his case against Wood Gore was much different than the straightforward strategy that Depp had in his case. So since then, I've been kind of in this thing more and more, and things keep happening at a rapid pace. So there's plenty to talk about.
Yes. Yeah. It definitely. And to the point that there's so much going on and there are so many different cases happening all at once that it can be tough to keep track of. So interesting. So how long have you been practicing, and when did you decide to start your channel?
Let's see. I think I got admitted in '94. So like Stone Age tablet stuff and all that. And I've had this channel for a while, but it was related to other things. And it really wasn't until I read the Manson lawsuit that I thought, well, I'm going to try and explain why this is a little different than the Depp case. And then I talked a little bit about my understanding of the Depp case after watching other people talk about it, just from a legal process standpoint. Like how does it stand and what's different, things that I can understand. I don't know all the facts and things, but I do like legal theory and high profile cases. I'm a fan of that. So I got absorbed into it more than I thought, changed the name over to Southern Law, and that and a little bit of guitar stuff is what I do on the channel now.
That's awesome. Awesome. So cool. So do you have any thoughts on how on, I guess, the underlying facts of the issue? I personally am still undecided on this case. I feel like I personally haven't seen enough one way or another to make a decision, although there are certain things that are definitely eyebrow raising, like the FBI letter and stuff like that. But what are your thoughts on kind of where you land on this case so far?
Well, one thing I think is there are surprises coming. So I don't want to be too certain on either side. I feel like both sides have not dropped all the bombs they've got or will get. And some of the dodging of discovery, I think, is related to some of the things I think Manson maybe has, and also some of the things maybe the accusers have that they don't want to put out there yet. Manson apparently has had access to Gore's iPad and also, I believe, a computer. Who knows what all he has off of that? And there are some facts coming out and things that color the credibility of the people involved, and that can change how you feel about it. I didn't come into this as a fan or non-fan of Manson or would say, so it's pretty neutral in that regard. But I'm not slam dunk either way on it either. But I look at what's the evidence coming in front of us now that you can actually evaluate. For example, this FBI letter looks really bad, and it's a central fighting point in the current Wood Gore case. So I look at those things. I mean, I have some opinions on credibility, but they're not any better than anybody else's, and probably weaker than other people who know more of the underlying facts of the cases.
Right. Yeah, I'm the same way. I actually, in some regards, I have talked a lot about how, growing up, I was kind of afraid of Marilyn Manson. and I think that was a lot of that is just kind of by design with his aesthetic and the things that he does and sort of part of his message and what he wants to be all about. And so for me, if anything, I when it comes to like their artistic work, I'm a bit more of a fan of Evan Rachel Wood's kind of work. Like I like Westworld. It's a great show. I've seen some of the other movies and stuff that she's been in. And so, but in terms of the actual facts in this particular case and all of the allegations and whatnot, I don't know, maybe it's just because of like when you've had enough sort of training in law school and through your practice and whatnot, you get used to taking on a client, and regardless of how you feel there might be more that's good or bad for this particular client, you'll still do a particular job in representing them and trying to get the best outcome for them. So it gives you a lot of practice of like being able to sort of like set aside your own personal feelings and just doing a particular job.
Well, I agree. And also, if you represent one of these people, even if the person you represent is the slime ball, or you think they're an angel, if you're not able to see the other side's point of view coming at you, or the third party, the judge or the jury, you can't structure your case to defeat those points. And I think, if you're just a fan, say, of Manson, and you're just going to like everything he does, you're free to do it. You wouldn't be a good attorney for him. They have to be able to see what are the appealing points of each accuser's case, and then how to rebut those. So that is, I think, part of being an attorney, is you have to be able to pull yourself out of your own biases as much as you can to look at the holistic things, so you can not only develop a good case, but also get a feel for what's a fair settlement as this thing moves along, because most cases, of course, end up settling.
Right. Yeah. And that's an excellent point as well, that, the attorney that's representing the client also has to be able to see the weak points, so that you can either try to maneuver around them, or understand when that hurdle is just a little bit too high for that case to get. And then you change your goals of the litigation, because you might have different goals going into it. That doesn't necessarily mean taking the case all the way to trial and then winning a verdict. So cool. So let's talk about, I guess, the latest thing that sort of happened that a lot of people have been talking about recently. I totally meant to have a video last week on it, but I wasn't able to get one out. So I figured this is a great time to talk about it, is the anti-SLAPP discovery motion that Marilyn Manson filed. And it seems like it's mostly a loss for Manson, because he wanted to get a handful of depositions. He wanted to get Ilma Gore, Evan Rachel Wood, the FBI agent whose name is on the FBI letter, and then I think one other person, or maybe two other people, I can't remember. And he's only able to get Ilma Gore, and on a very, very limited scope. So what were your thoughts going into, like, when that motion was filed, and when you read the paperwork on it? Did you think that he could possibly win on some of those?
I thought he would, and for a couple of reasons. One, while there is a general discovery stay in these cases when an anti-SLAPP motion to strike is filed, it can be lifted for good cause. And good cause can be if the other side has possession of facts, and you convince the judge that if I can just do this thing, it's not very burdensome to them, I would be able to show I have this case. Don't let them hide the facts from me. So I thought, well, he's going to be able to get some discovery from Gore and Wood through that logic, and also the logic that this won't be that burdensome to them, because this case will survive the anti-SLAPP motion because it has causes of action in it that are not subject to the anti-SLAPP. So there's no way the whole case can be just dismissed at this stage. So they're going to do discovery anyway. So why not let him have some? Now, I was skeptical that he would be able to fly to Florida and try and subpoena an FBI agent on what they claim is some kind of active investigation, when the agent doesn't have to comply with that if the government doesn't allow it. Plus, you're going to Florida. And I think one of the other witnesses was in New York. Says, to me, that starts to tilt over to the burden part, because for a motion to strike, the plaintiff has to show, hey, look, I have a good case. I've got evidence to support my case. And you can't really rely on general, wide-ranging discovery to formulate that, because otherwise, what's the point of having a discovery stay? So I thought the judge would split the baby down the middle, give him Gore and Wood and maybe a local witness on certain topics. But it looked like to me she just like cut the baby's leg off and gave Manson, the one little deposition and not the rest of it.
Yeah, maybe just a toe.
Yeah.
Yeah. Yeah, I was a little bit surprised somewhat, although I was kind of on the fence, to be honest, because I know that in California, the anti-SLAPP laws are very strong in California. It's not like Virginia, where we were talking about anti-SLAPP at the end of the trial in the Depp case, where that was just like a general defense that Amber Heard was able to use, like at the end of all of these things. It's in California, they're very serious when they say that, like, if they think that this litigation is potentially, it's not vexatious, that's not the word for it, but improper, because of, they're using their First Amendment rights, and that's what they're being sued for, that they are very, very serious about it. And you're exactly right that the discovery issue is something that it would kind of render all of that useless if they were able to just go ahead and move on with discovery, because that's usually where most of the expense is in any kind of lawsuit. So now we've got, and basically the reasons why the court said is that, I mean, she basically said that she leaned over towards the overly burdensome side, right? Because, as you said, the discovery, in order for Manson to win on the discovery motion, he had to show that the requests that he was making were pretty narrowly tailored to only what he needed to answer for the anti-SLAPP motion. And at the same time, he had to show that it wasn't going to be a massive burden to the other side. So the court, I think that sometimes the courts will look at even where other claims will survive, you'll have, the court will say, well, this is an overall expense that they still wouldn't have to pay for these kinds of, like, getting into these kind of topics for depositions and stuff. That's still time that you have attorneys sitting there at the deposition preparing for it. Like, all of this stuff costs money at the end of the day. And that would end up resulting in some way an infringement or a tailoring, you could say, of someone's First Amendment rights. Like, just if you were to assume that it is true that these are their First Amendment rights and this is improper litigation, right? So it's like you kind of have to put the cart before the horse in some of the analysis for some of this stuff. But what are your thoughts on what this means for going into the anti-SLAPP hearing? Because now this was like part 2 of the anti-SLAPP overall fight, right? So for folks watching, there was the anti-SLAPP motions that were filed by Amber Heard, Evan Rachel Wood, and Ilma Gore. Don't take that as a Freudian slip, guys. As Evan Rachel Wood and Ilma Gore, they both filed anti-SLAPP motions. And then Marilyn Manson filed this discovery request to say that, I need discovery so that I can respond to these motions. So those motions still have to be figured out now that the discovery motion has been figured out. I think he still has an ability to come back with an opposition to both of them and to really craft a response. What are your thoughts?
So before I speak to that, I would say one thing about the anti-SLAPP, because I didn't know much about it before I started watching the Depp, and then the California stuff, of course, is a very significant area of law in California, the whole anti-SLAPP practice. But people need to remember, because I've seen some people say, "Well, you just can do whatever you want and you don't have to." No, that's not the case. It's a two-pronged thing, and the first is that the defendant shows that the activity that they're accused of comes under the protection of the anti-SLAPP, like a free speech kind of a thing. That's not immunity. All that happens then is the court looks to the person who did the suing, the plaintiff, and says, okay, this is a First Amendment style issue. You need to show me that you have a case, that you've got some evidence to support what you're doing. And if you can't do that, I'm going to dismiss your case. It's no immunity at all. So,
Mm-hmm.
so in this case, like you said, he asked for limited discovery. His attorneys, I thought, did a great job of developing a chart saying we're tailoring this as narrowly as we can. Still thought it was a little bit much for New York and Florida, but whatever. So he didn't get it, or he got just a little bit of it. But that's not the end of the story. He gets to oppose the overall motion to strike before the hearing in December. He gets to file an opposition to it. And to me, the significant part of the court's ruling, besides not giving Manson what he wanted, was what she said about a lot of the allegations. Like, she didn't see the FBI letter tied into, outside of it being filed in the child custody case, actually being shown by facts to be used against Manson. And then she said she didn't find the recruiting aspect of what Gore was doing to be extreme or outrageous conduct. And those two things, therefore, he's going to need to do something about that, because there were only 3 speech-related aspects of the intentional infliction claim, the last one being the defamation, and the judges, it's not going to throw that out, at least as to Gore. But like you said, to me, she tipped her hand like, I don't see Wood as part of the conspiracy for defamation. I don't buy these statements as outrageous. I don't see this FBI letter being connected. But she didn't rule on those things. So he has a chance now, knowing the judge's mindset, to develop the argument the best he can and bring up whatever evidence, file some more evidence if he can get it, and the best arguments he can before the hearing in December.
Yeah. Yeah. I think that the allegations in the complaint about Evan Rachel Wood with the IIED and the defamation, like the conspiracy aspect of her consenting to and encouraging the statements of Ilma Gore. I remember looking at that and saying, this is probably one of the weakest points in this complaint right here, because it's not quite enough to say, I mean, maybe it's enough to like just barely survive a motion to dismiss, but I think that it's just that. It's a very weakly stated allegation there. I would have, if I were, on the team that's drafting that, I would have wanted to put something a little bit more robust in there to say what other things that she did to encourage or promote or to amplify those statements or something, or republish those statements or something, because those that was probably the weakest part of the complaint. But I do think that you're correct in the fact of her tipping her hand. And I almost wonder, it made me think, now his attorneys are, I mean, these are big attorneys. Like, they're not, like, it's not a small mom and pop kind of shop that, takes all kinds of cases, and like sometimes defamation cases. Like, they know what they're doing here, right? These are very sophisticated attorneys in this kind of a case. So I wonder if maybe that was part of the reason why they filed that discovery motion in the first place, is to kind of see if they can test out some of these arguments with the judge, and to find out like what would actually land. Do you think that that might have something to do with it?
Well, I hadn't thought of that. That's some good 4D chess. What you just said, though, would be an extremely good strategic reason to do what he did. Whether he did it on purpose or not, of course, he gets a reward for it, which is an insight into the judge's thinking. But if they thought ahead to do what you just said, then that's pretty brilliant.
Yeah, that would be. So either, I mean, but maybe they just stumbled into it. Who knows? So yeah, I think that I think if I were to sort of restructure some of those arguments, I would stay in terms of the FBI letter. I don't know, and tell me what you think. What I would do is I would probably try to stay away from any kind of allegations about or arguments about her using the FBI letter in any kind of a court proceeding. Because, and to say like, yeah, she used it in a court proceeding, but she also used it in all of these different places. And that's the part that matters here. That's the part that we really care about. We don't care about the fact that she used it in a court proceeding. We care about the fact that she, spread it around to all these other people to try to convince them to join in on this like conspiracy or something. What are your thoughts on how you might recraft that argument?
Well, I agree with that, and I think while you're talking, I'm thinking about this, and we'll say the anti-SLAPP what motion was filed to completely strike the defamation claim, and then on the IIED claim, just to strike those 3 speech elements that we're talking about. And one of them, to me, which is really important, is the FBI letter, because it looks really bad to me from a credibility standpoint for Wood, because it appears to be a fake document that was used in court to bolster her legal arguments in a custody hearing. And if that is what it is, then it shows she maybe doesn't have the limits that somebody who you want to trust should have for what she's willing to do to win a case. Now, she says that's not the case. In fact, she filed an affidavit opposing or supporting her motion to strike, opposing the discovery, saying that I didn't know it was fake when I filed it. I thought it was real. That's interesting. I would like to see that tested in a cross exam, because if that were to be true, it would restore a lot of, what I think about it. Because to me, that looks terrible. So Manson, of course, wants that in the case badly. They don't blame him. The problem is that the judge says what you just said, which is, don't talk to me about her filing the child custody case, because the privilege for that is very strong. But where is your evidence that this was used? And if Gore and Wood hid in a room and closed the door and wrote a fake letter and never showed it to anybody, well, that's not a cause of action either. So you're going to need to show me how this was used against Manson himself outside of litigation. So now they do have the chance to do that before this motion is heard. But I haven't seen that. I haven't seen a witness yet come forward with an affidavit or something and say, hey, I was shown this FBI letter and they told me I needed to join in. Now, if he can, and maybe I missed it, but apparently if I did, the judge did too. But if he does have that or can get it before December and file it, then I think this letter stays in. If not, the judge seems to think this allegation would go, which would be a big blow to Manson, because it's one of the biggest bombshells I thought that he dropped in the first place in his case.
Yeah, no, I definitely agree. And I think that's the thing that most people that I think are supporters of Manson in this case point to first, because it is something that, I mean, as an objective observer, you look at that and you see, I mean, how would that look to a reasonable person? Like it's from the FBI, like it's just, there are many issues with that letter. So, and I completely agree. I think that having Evan Rachel Wood be cross-examined on that letter is very, I would think, beneficial to Marilyn Manson, unless she has some very good reasons for, where she got it, who gave it to her, what were the circumstances? Was it mailed to her? What kind of an envelope? What kind of, like, did it just show up on her windshield? Like, how did she come across this letter? If she didn't draft it herself, or if she wasn't involved in the drafting of it. So, and it could very well be that she's got some very good reasons for it. And she's, just was very unfamiliar with, the FBI and legal processes, and, and maybe she just was very naive and thought that was a very real letter. I don't know. But it would come down to her responses on that. So I think that just for my own personal curiosity, I personally find myself hoping that claim survives, because I want to know exactly like what happened around that letter. And if that claim goes away, we probably will never know. So it'll be interesting to see what happens with that. And I think that I did actually kind of agree with the court with what they said about the witnesses that they had attached, the declarations of like the people that Ilma Gore had reached out to, the text messages that they show that they attached to all of that, saying like, it basically amounted to her saying, hey, we've got some people that experienced some things with him. If you experience something similar, no pressure or anything, but come and join us and we'll talk, or something like that. And I remember seeing that and saying, I mean, that sounds like a solicitation of come participate, but come participate in what is a little bit less clear for purposes of Manson's side. I mean, I can see how Evan Rachel Wood can point to that and say, like, this is just an invitation for people to come and participate that have been victimized by this person.
Well, and for intentional infliction of emotional distress, people have to understand that the actions that you allege to support that claim, they need to be extreme and outrageous and outside the bounds of civilized society. They can't just be hey, they did a little bit of a kind of a bad thing here. I mean, they shouldn't have been doing this. You have to really say something really bad. And
Yeah.
that's, I think, kind of what the judge said in her order was that these statements by themselves, they're not extreme and outrageous. And that if they get kicked out, this whole pressuring thing, if the FBI letter gets kicked out, and it's interesting that only Wood moves to strike the FBI letter. Gore didn't join in that piece. I actually put the complaints next to each other for what they were seeking to strike, and that's all the difference was the FBI letter accusations. But that's something I tried to look up and didn't find a definitive answer, maybe just because it's common sense. If Wood is successful to strike the FBI letter allegations, I think that's just struck from the complaint. There's not like two versions of the complaint with
Right.
Gore having it. And that's one reason why it might have been better to allege more, make a longer complaint with more causes of action that, like you said, laid out the conspiracy in greater detail and maybe independent causes of action for each one, so that the FBI letter was in a separate cause of action for Gore away from Wood based on her own actions, because they could lose the right or the ability to talk about this FBI letter potentially. And that's a swing point, I think.
Yeah. Yeah. I think, yeah, I think you're probably right about that. Now another thing that is a possibility. Now we haven't seen the opposition that Marilyn Manson's going to be filing to that motion, the anti-SLAPP motions. So he'll be filing two oppositions actually. So that'll be something to parse through when it does get filed. But and I would anticipate that'll be after October 27th, since that's the deadline for Ilma Gore's deposition now. And I'm wondering if they'll be asking for, I mean, well, I'm thinking that most likely what they'll be asking for is alternative remedies, right? To say, like, number one, we ask you to deny the motions outright, but if you do grant them, at least give us a chance to fix up our complaint so that we are alleging other things. So for example, for the conspiracy claims, for including Evan Rachel Wood in these other activities by Ilma Gore. What are your thoughts on that possibility?
Well, I think I had checked a while back that, and I'm not sure about this because I am just a tourist in California, a virtual tourist, but that they're kind of hesitant to allow you to amend a complaint at that stage of the motion to strike, because then that kind of, it's like you need to put it up to begin with if you're going to be suing somebody over their speech activities. We don't want to freely allow you to amend, which normally you can kind of freely amend at justice. If you've got the facts on your side, you shouldn't be thrown out on a technicality. I think maybe that they're harsher on this, but of course she could still do that. But what I wondered is, if they got these depositions of Wood and Gore, what else did they get off of this iPad and this computer that they had access to? Was it really just what they filed in Brighton's declaration? If you look at it, there's a little scroll of photos down at the bottom. If she got a lot of material off of this, that may have been things they wanted to bust on them during the deposition. And now they may have to put it up just to survive the motion to strike, because it seems weird that there's just that one little set of text messages about this letter. And maybe there's information, kind of smoking gunish information, that they wanted to bust Gore or Wood on, that at a deposition without tipping their hand that they actually had it first, that now would be the time probably to put it up. So I would not write off Manson's opposition to the motion to strike. I know his fans feel kind of defeated by the judge's current ruling, but that says nothing to what he may have up his sleeve. We won't know that until, like you said, until he files his opposition.
Yeah. So, and so that one, like I said, I would expect that to come out at the end of October earliest.
I think sometime, if they're allowed to do it, probably the later for them, the better. So mid-November or maybe later. I don't know what their actual deadline is. I think it's pretty short before the hearing.
Yeah, that's right. I've got to check the statute again. It's you do all kinds of math. It's like you do math from the date of the hearing. So it's like I think the reply is like 5 days before the hearing, 5 court days before the hearing. The opposition's however many days, like 2 weeks before that or something. So yeah, exactly. So I've got to double check the statute and do the math, counting court days versus calendar days. It's that kind of stuff can get complicated. And people can get tripped up on that very, very easily. It has happened. So that's basically that for the Evan Rachel Wood and Ilma Gore case. Now we've got the hearing is on December 1st, I think, right? Do I have that right?
Yes. Yep.
Okay. And so that's basically what we haven't even gotten into like any of the substantive claims here, right? Like we're just doing the very beginning basic motion practice.
Hmm.
So that's really the crazy part about all of this. So we'll see if it survives. I mean, I wouldn't, I'm not going to lie. I personally would like to see it survive so that we can see, what kinds of discovery would come out about the FBI letter, about some of these statements made about the groupie video and whatnot. But I think that was, actually thinking about the groupie video, I think that the reason why the court really found that the Ilma Gore deposition truly was something that he couldn't get anywhere else is because he has to show actual malice for the statements that she made to other people about the groupie video. Because number one, so remember that he's got to show that not only did she make a statement that it was false and that she, that there was harm that resulted from it, but also that she knew it was false or that she was reckless as to the truth, right? So she could have been mistaken in who she thought was the actress. So that's something that are going to have to parse through in that deposition and try to pull out of her. And I would anticipate that she probably would say, no, I didn't know who Paula Weiss was. I was mistaken, or something along those lines. So I I'm wondering what's going to happen with the deposition, but I suppose we'll get that information in his opposition, because he'll be attaching the relevant transcripts from the deposition to his opposition.
Yeah. So far as I know, sorry, in this case, there's not been a protective order for confidentiality. So it would be available for us to see if that doesn't change. And if you're on Gore's side, that's not a good sign that the judge said, hey, he's got good cause to talk to you about this defamation claim. I mean, that clearly suggests to me she's going to leave that claim in. And I believe under California law that defamation can be an underpinning for IIED. And so if you're Gore, that means probably both claims against you are going to survive this motion to strike, and Wood's in a better position. But if you're Gore, it looks like your ride's going to continue. Although, and correct me if I'm wrong on this, once the judge signs and the ink dries, after that, either party, whoever loses, they can just appeal this thing, and that probably shuts this case down, I think.
That is also true. This case could actually be put on ice for a good long while one of them appeals, and it would essentially freeze the entire case until the appellate court decides on that. So depends on if they want to go for that fight. We'll see. I mean, either side, as you mentioned, can appeal immediately. So yeah. Well, let's turn to the Esme Bianco case, because that's like the second one that has had like a ton of activity in this case, because they've got, it seems like, it's I really empathize with all of the people that are trying to keep track of all of the different plaintiffs in this case, because it doesn't help that they are also showing up as third parties in each other's lawsuits. So it's almost like it's kind of like the Marvel MCU, where you've got, Thor showing up in an Iron Man movie, or like Captain America's showing up in like the Hulk, so we've got Esme Bianco, her case. She's got depositions for Ashley Morgan Smithline and for Ashley Walters that are supposed to be coming up, but they've been fighting about them. So what are your thoughts on what's been happening in that case?
So one thing to remember for people to know is that the Bianco case and the Smithline case are in federal court, and that has its own set of rules of civil procedure separate from the California state courts. So just to keep the fun of complexity high, the judges are different, the rules are different, and all of that. And it wasn't long ago in the Bianco case when the parties jointly came together and shook hands and gave the court a joint declaration of how they were cooperating on discovery for the purpose of getting an extension of that. And only a few weeks later, you get all these blast out filings because Smithline and her attorney's relationship breaks down. And the deposition gets canceled on last minute with Ellwanger filing his motion to modify the subpoena to give her more time to comply with it. And then Manson's attorney's filing a lot of paperwork saying, look at this, judge, this is crazy. They knew this was coming. She was lying. He was lying. They were all lying about why she wasn't showing up. She says she fired him in May. She's been calling us. She's calling him worse than a fruit bat. It's awesome. It's crazy. It's voicemails, text, a stove video of firing her attorney. It's just all wild, right? Now that is all only filed in the Bianco case and not Smithline's own case, because like you said, Smithline came out of her box over to the Bianco box to appear as a witness under subpoena as a witness in Bianco's case. So it involves both cases, but the fun of the crazy allegations right now is primarily in the Bianco filings. And the court said, okay, we'll hear this motion to quash with all this nonsense in it, but not until the withdrawal motion is decided over on the Smithline box, which that was supposed to occur last Friday. And it was at 1 o'clock or whatever. And yet, as of this morning, when I checked the docket, they haven't mentioned it at all over there. So I don't know what's going on with it, and therefore how it would impact her deposition stuff over in the Bianco side of the case.
Right. So because there's like these multiple issues that are happening. I mean, we could just talk about Ashley Morgan Smithline just particularly right now. She's got these two main issues, right? She's got the deposition that was supposed to happen a while ago now, like weeks, over a month ago at this point, I think. And then she's got the issue of the withdrawal of her attorney, who also represents Esme Bianco. So he's an Austin attorney, went to my alma mater for better or for worse. And so he's been representing both of them. And there are certain professional responsibility issues that have sort of exploded out of that case because of a lot of the things that Ashley Morgan Smithline has said, or at least that Marilyn Manson's attorneys have said that Ashley Morgan Smithline has said. It seems like either, to me, like my impression of the representation issue, right? Ellwanger representing Ashley Morgan Smithline. This question of whether she fired him back in May, as Marilyn Manson's attorneys are saying, or whether he just recently withdrew within the last few weeks, as Ellwanger is saying. So there's that particular issue that's coming on. And I'm wondering if maybe one of two things are possible that could be happening here. Either she actually fired him back in May, or maybe she fired him in May and then rehired him, and maybe at several points along the way fired him, rehired him, because that sometimes can happen between attorneys and clients too. What are your thoughts on the possibility of that, or the likelihood of that happening?
Well, it's pretty wild. Some of the disclosed stuff is, let's get on the phone together and talk. I don't want to be fired over a video that starts with a picture of a stove on it. And that would be unorthodox. And he would have an obligation. If you get fired, you're supposed to get fired. You're supposed to get out of the case. You don't get to just keep representing somebody. But if you're in litigation and before you get out, you need to advise the client, now, look, this is what's coming down for you, right? You've got a deposition scheduled. You've got various things. So you need to get another lawyer, or you really need to take it seriously to understand what's happening, because things can happen to you that you just don't understand because of court rules. So, and that, he pretty much said he was going to do that. What we don't know, and because he said, hey, judge, I'll show you in camera, which is basically in secret with the judge. I'll show you the text that proved that this relationship was not severed. So his side of the story is not out there for us to see, but he has said he has a side of the story. And it could be the stove video firing him was followed up by a freezer video saying, I'm glad we were able to work this out and let's keep going together. And then followed by a washer dryer video. I hate you. And we just don't know all those things, right? So, and I got a message from somebody well before his motion to withdraw saying he's not her lawyer anymore. And this was before this. And so I went and looked on the Pacer, and I'm like, he hasn't withdrawn. He's still showing his counsel records. So I answered the person who brought it up. I'm like, no, if he wants to get out of the case and not be her lawyer, then that would show up in the court record. You don't get to just stop doing it. You have to, if you're the attorney in litigation, the court has to let you out. You just don't get to do it yourself. So I feel like, and I'll admit this on your channel for the first time, that I'm one of the few people on this planet who has not received directly a message from Ashley Smithline. No DMs, no stove.
I haven't either.
Nothing.
Yeah. No, I haven't gotten any messages from her either. For better or for worse, I also haven't tried reaching out to her in any way. So, because I feel funny about that. I mean, being an attorney, not that I'm I would be looking to represent her in any way or to try. I feel funny about that. So yeah. So I think that that whole issue that has erupted is so interesting, and I do think that we do definitely have a gap of information as to the other possible messages that could have been passed back and forth between them. And he's really in a tough spot in terms of the professional rules of conduct, right? Because he's not allowed to disclose the conversations that he has with his client, even if she's making these kinds of allegations. She can disclose those because she's the one that owns that privilege, so she can waive that privilege and say, this is what we talked about, this is what I said, this is what he said, and she can say that to anyone and have zero consequences. That's fine because she's the client. The attorney, on the other hand, has all kinds of consequences if they disclose those communications and they haven't been waived. So the opportunity to do an in-camera review with the court to say, you can take a look at these, not waiving anything, not disclosing anything, like just for you to see that this is not the full picture. I think that probably is the smartest thing that he could do under those circumstances at that point. But I will say some of those communications really, really raised an eyebrow that we were able to see publicly. Like his it's interesting because it's like the attorney has a responsibility to make sure that the client, if they are saying that they want to fire the attorney, I mean, of course, withdrawing from the representation, saying, okay, I'm hands off, right? Like time is up, hands off, not working on this project anymore, except to the extent that is absolutely necessary to make sure that your rights don't get, infringed in any way. So they're like, there's some nuance to it, but for the most part, hands off. But, and the attorney, I think it's good practice at the very least to say, look, I want to make sure that you understand what it is that you're doing by firing me, and that you understand what the consequences are. And, so that you have the ability to find someone else to help run things, manage the ship, and, make sure that you are getting what you need. But his communications seemed to, maybe it was just like my particular filter, but when I was reading them, it looked like they were like he was pressuring her to stay in the relationship, which to me seems a bit different. I don't know what your thoughts on that were.
I guess my thoughts are consistent with that in terms of what was released looks bad. But, he's an attorney, I'm an attorney, sharks don't bite each other that often. It's even harder to get an attorney to sue another attorney, that sort of thing. So I want to give him the benefit of the doubt when he says he has a story. And remember, he told a federal judge, I can back this up. I was not fired before August 17th. So that's significant to tell. I mean, I would not directly BS any judge, especially a federal judge. And if I can just show you in camera, Judge, you'll see that we had an ongoing attorney-client relationship up until the time that I asked to withdraw from the case. And he doesn't show the judge that. So I think, he's probably got something there, or certainly he should have. I mean, we're not aware of any history of his where he's been in trouble or anything like that. So I give him the benefit of the doubt there. And again, remember that the silos there. The Bianco whole discussion about this, was he fired in May? Is he a fruit bat? Is she talking to Howard King on the side? Is only relevant to the motion to quash him, whether it was legitimate for her to skip her deposition. It's not over on her own case, where he's only filed a motion to withdraw, and Manson's only response in Smithline's case is, we don't oppose it, Your Honor, as long as we get contact information from Ms. Smithline if she doesn't get new counsel. And people should understand that, when you do want to withdraw out of a case, the judge isn't supposed to open an inquiry and say, and do like a mediation, like, hey guys, you guys got to tell me about how this break down. tell me the score on this. If they should let you out of the case if it's clear the client wants that and it's not going to disrupt the court and stuff. And there are limits to what they're supposed to do and ask the judge about going in deeply into the background of this unless it's just necessary. So in her own case, it seems like that's very tame, kind of normal. Hey, he wants to get out. We don't have a problem with that, judge, as long as we got somebody to contact. But over on the Bianco case, it's the Wild West, but everybody's a liar and he's a fruit bat and the stove video, and it does all look bad, just like you said. And judge, if you let me show you in camera, I can show you this is a bunch of baloney. And then of course he fires back with his own motion for sanctions in the Bianco case, which is all under seal. So they went from we're all getting along on discovery to all kinds of motions, just tearing each other a new one over there on the Bianco side. But on the Smithline side, they're just sitting down and getting along together. Let's work this out. But as soon as they change rooms and clock in on the Bianco case, they're trying to kill each other.
And it's crazy because it's all the same attorneys too, right? Like it's all the same people that are having these fights and these different conversations. It's wild. Now one of the things that Ellwanger fired back at Manson's attorneys for is the communications by Ashley Morgan Smithline to Manson's attorneys, that she left a voicemail and they didn't back in May, I guess they didn't like reach out to Ellwanger to say like, hey, we got this weird voicemail, like just, so this is what she's saying. We haven't responded to it. So he basically tried to say that they have violated the rules of professional conduct with that. I remember looking at it and basically coming to the conclusion that they probably didn't have any issue with not reaching out to him because she didn't disclose any kind of communication with him. I mean, at least I haven't heard the recording. So, I don't know specifically what she said, but it sounds like the gist of it was that she intended to communicate with Manson's attorneys. She didn't think that she was calling Ellwanger and having some confidential conversation with him. So there's no real issue with them saying like, hey, we had this improper disclosure that we didn't intend, we didn't try to get anything. So what are your thoughts on like that side of Ellwanger's sort of response?
I agree with that. I did look at it a little bit because California rules are different than North Carolina, sometimes in material ways, but that one didn't strike me off the cuff. If she just left this voicemail, is like they have to talk to him. Now, what King did when he got an email and responded to her, he said, I can't talk to you unless your lawyer wants to let me do that. And he is still your attorney of record. And then he does tell Ellwanger that and says, look, your client has said she's not working with you anymore and she wants to talk to me. Can I do that? And he's like, no, you can't do that. So that makes whether he's still her lawyer or not, for purposes of that, pretty material. And is that really her communicating with Howard King? I mean, how does anybody even know what she truly has done or not done? Because she could have provided an affidavit to support Ellwanger leaving the case or clear up this motion to quash or something. She hasn't, to my knowledge, I guess I'm saying she hasn't done anything in public other than DM people and text people and email people, which I don't see her doing that. How do I know it's her? There's a limit to that. And if I'm the federal judge, I'm going to say, if you'll give your contact information over for your new lawyer who's going to appear or for yourself, then I'll put this deposition off 2 weeks and then let them depose you and you guys get out of here. I don't want to get into this mess about fighting with attorney and client. If you leaving the case solves all that and she's happy going forward by herself or with this new fancy lawyer that she does like, let's just do that, guys, and get out of my courtroom with all this nonsense. So if I were the judge, I'd try and condense that and just move this case forward. And I thought that's why they put off the motion to quash, because they're like, let's see how the motion to withdraw is settled, because if he successfully withdraws out of the Smithline case, then they may say, we don't want to hear it anymore. You don't have to come in camera. I don't care about it because your own client is now her own representation in her own case. But we will put the deposition off, 2 weeks, 3 weeks or something, not 90 days like he asked for. And we'll see you later and get out. And if you come back, then we'll start sanctioning people left and right.
Yeah. Now that brings up, sorry. Oh, sorry. You were going to say?
No, I just said that's my opinion. Who knows what they'll do.
Yeah. But that brings up another point that when you start looking at the full landscape of all of these cases together and how they can all impact one another, you've got the Marilyn Manson responding to the anti-SLAPP motions over here, and then you've got Smithline, you've got Esme Bianco. He has a deadline for that opposition, and he indicated in the discovery motion that he was going to be using some of these depositions in these other cases for his opposition to the anti-SLAPP motion. So I'm wondering if he can possibly get, like, if these other depositions do get delayed and he's intending to rely on those, I'm wondering if he has any possible remedy to try to get those other anti-SLAPP motion deadlines pushed back as well. My guess is probably not, because the judge there has already basically said, like, no, you can't get this extra discovery, and no, I'm not going to hold off for you to get other discovery in these other cases elsewhere, because, you know, like, you didn't even ask for these depositions under our scope, and so no, sorry, too bad, so sad.
Yeah, I completely agree. I don't think she would waive that off. She, as you said, she only gave him a tiny part of what he asked for in his direct case there. So for her to hypothetically hold off for other people, that would be almost an admission by Manson that, hey, when I brought this case, I didn't really have any evidence at all, man. I was going to need discovery from like 16 cases, in order to support any of this stuff. I mean, give me a break. I got like 1,000 people I got deposed to get one cause. That's not where you want to be, is saying, I have nothing, Your Honor. Please put this off, when your obligation under the anti-SLAPP is to show you do have a case. So I agree with you. I think that would likely be a loser.
Yeah. So, but that could potentially put him in a bit of a bind for those anti-SLAPP motions if these other depositions continue to get delayed 30 days, 60 days, 90 days. It's really putting pressure on him to show in some other way, I guess, that he has a likelihood of succeeding on the merits of that case against Evan Rachel Wood and Ilma Gore. So there's that one, and then there's the Ashley Walters deposition too. That's been delayed. This one I've got a little bit less, I should say fewer touch points on this one, because I've been traveling a bit. So I remember going through it and reading through it, and that one was also pretty spicy, you could say, between the two sides, in terms of like what they were agreeing to, what they weren't going to agree to. So what are your thoughts on the Ashley Walters deposition that was supposed to move forward, and now the judge ruled on it? I can't remember what the judge's ruling was on that issue.
They're having a hearing on the 19th on that.
Oh, that's right.
Yeah. Okay. And as I read it, if you take out all the inflammatory emails and the back and forth of this and that Manson wanted to question her on her communications with Bianco, Gore, and Wood. And she was willing to be deposed on her communications with Bianco, saying, hey, that's the plaintiff in this case. I'm willing to do that. Manson's guy said, well, we're not willing to live with that restriction because this was a conspiracy and we're only asking for 3 people. So that's what we want. And if you're willing to come to the deposition and only talk about Bianco, then we would reserve the right to come back later and ask you about these other things if we need to. And her attorney said, no. If we come once, we're not coming again. And I feel like, now I'm old school. I already told you when I started practicing law back then, discovery was everything. It was all burdensome. It was all fishing expeditions. It was all designed to put the pain on people. I think it's not so bad anymore. But to ask for her communications with 3 people that are material to the case that were related to what Bianco was doing, that seems very reasonable to me. But I think there are 2 good reasons why her lawyers object. And one is an overall strategy to put these depositions off hurts Manson in the Wood Gore case. And hurting Manson in any case, if you're these women, even if you're not fully collaborating with each other, is probably helpful, because as you shut cases down, shuts down avenues for Manson to fight back. The other thing is, she may have had very little communication with Bianco, and that's why she's willing to talk about it. But her communications with Gore, because if you go back to the Manson versus Wood Gore case, he alleges it was Ashley Walters who provided Gore with his passwords, personal information, and things. And so that was certainly going to be a topic which would help Manson in the Wood Gore case and would also make her look bad. And just to make sure everybody knows this is a tiny globe that we're all on, she had her own case against Manson that was dismissed under the old statute of limitations, which is on appeal, and therefore probably stands a good chance of being reinstated because of this whole statute of limitations change that's going on. So there's,
Yeah.
again, to make sure that no one can grasp this on any tiny little flow chart, it's all interconnected in so many ways.
Yeah. Yeah. I feel like Charlie from It's Always Sunny in Philadelphia, that meme that gets passed around all the time with the red lines that are passing around, or that are, going from photo to photo. Um, that's what this case really feels like. Yeah. So the Ashley Walters, her case, her proper case, yeah, that was dismissed on the grounds of statute of limitations, meaning that she waited too long to bring her case. Now, what Steve was just alluding to was that there was a recent change in California law that they did bring into law, the ability to essentially extend the statute of limitations for these kinds of cases by a few years. And so that probably is going to cover Ashley Walters' case. So by the time an appellate court sees the briefing on that case, they probably are going to say, yeah, there's this new law, and then the question is, does it reach back? Does it not? Which I think it probably would. So she would be able to bring that claim back, most likely.
And to nerd out on that a little bit, I found California law that says that a case is considered still pending as long as it's on appeal, and then the statutory change, because originally they did not draft the new statute of limitations to be retroactive, but they have done it now, and it applies as long as the case has not been litigated to finality. And so if it's considered pending, I think she will get this relation back, and so her case can come back in, because some people were like, well, why did she bother to appeal? It was dismissed and stuff. Well, that's why, because with this bill pending and now being passed, she has an avenue to have her case restored, because it was thrown out because she couldn't get the judge to buy into her argument that the discovery rule gets her around a statute of limitations, that a recovered memory or something like that applied. And so she only found out about, what happened to her within a recent period. The judge was not convinced that she had the facts for that. It had nothing to do with whether she was abused or not, just the timeliness of her allegations.
Right.
And so her case thrown out on that, but it might be thrown back in, by the Court of Appeals at some point as the statute of limitations changes.
Yeah. Yeah. So that one is interesting, how that is probably going to come back. But in the meantime, she's a third party in the Bianco case for her deposition for that. But I do agree. I think that it's normally, so when we've been talking about discovery so far, we've been talking about it mostly under the context of the anti-SLAPP motions. And there we're talking about narrowly tailoring questions, so that they're very specific. They're only geared towards answering certain questions. But outside of anti-SLAPP, discovery is generally really, really broad. So anything, it's not just like, you can ask questions that are not just questions that you think are going to be like where the answer is going to be admissible in court. It's just questions. You can ask questions that will lead to information that you could bring into court. So it's very, very broad. This is why, like, when I've represented clients before that wanted to start litigation, I always wanted to have a conversation with them to say, like, look, now, just so you're someone who was fired by your employer and you want to sue your employer, you're going to get all of your finances looked into, your taxes, your pay stub, like everything's going to get looked into. I hope you're ready for that, because it's going to feel very invasive. It's going to feel very personal, but that's just kind of what has to happen in this process, because the whole point is that the courts will say, like, the parties need the ability to get access to basically everything to properly, fully evaluate their case, whether that's going to be, looking for the good stuff that they need to win the case at trial or what have you, or to find the bad stuff so that they can evaluate whether or not they need to settle. So that's why, it's very, very broad normally. So I think when I saw the request that Manson's attorneys had made for the document production and for the deposition for Ashley Walters about, the communications between her, Esme Bianco, Evan Rachel Wood, and Ilma Gore, all you really need is basically like a rational relationship, essentially, between these different people. Like, you just need like some kind of like reasonable reason for why you would ask that, and it has to be connected to either some kind of a claim or some kind of a defense. And his defense is, look, all of these people are in this conspiracy. This conspiracy was led by Evan Rachel Wood and Ilma Gore. So yeah, I want to know about your communications with these people. If there's nothing there, there's nothing there. And then I don't have a case. Great. But otherwise, if there is, I definitely want to see it because it's very, very important to my case. So, yeah. So yeah. But I think that the other thing about that though is that it almost makes me wonder if there probably is something there with her communications between Evan Rachel Wood and Ilma Gore, because sometimes you fight really hard for something that you really don't want the other side to have. What do you think about that possibility?
Well, the two reasons for the fighting, one being just as a strategic delay, which is always fun. The second one would be, again, it's only three people. And the argument that you can't ask about just three people, I would think would be completely laughed out of the judge, everybody, bailiff, people passing on the street, murder defendants, everybody joining in laughter that you tried to say that you wouldn't have to answer just to three people. That's insane. But I still go back to, we don't know what Manson has. Say again, this, the iPad, the smoking iPad probably was literally smoking because it's all smashed up. But he may have traffic, because he says in his case against Wood Gore, Walters gave this information to Gore. And if he has proof of that, emails and things like that, we don't even know if her own attorneys have that stuff. And so she comes into a deposition. Do you recall giving Ilma Gore this, that, the other? No, I don't remember. Well, what about this? What about this? And boom, boom, boom. All of a sudden, her video deposition starts looking pretty interesting. And his case against Wood Gore gets stronger. His case against Walters gets stronger. He's starting to, it could be a substantial defense. Now, I don't know that any of that's out there, but if I were her attorney and I were worried about it or knew it, why not try and limit this thing? And plus, it gets me the benefit of delaying it and maybe hurting him in his other case. So it's kind of a win-win. And since she's a third party, this isn't her case. The court's a little easier, at least is my experience, and I think the rules still support it, on a third-party witness before they start sanctioning you and doing things like that. If you're opposing a subpoena, is a little different than a party to the case. So I feel like she's going to get a free bite to oppose this, and then the court's going to say, well, you have to comply by blank date, or we'll modify it a little bit, and then it will occur. I still think Manson gets what he wants, but I think she'll succeed in having this delay without really any consequences to her, is my guess.
Yeah. What do you think about the fact that these plaintiffs, these women that have filed these cases are fighting hard? It seems like they're fighting hard to not have their depositions taken. That to me is a little bit suspect. It's a little strange because you're the one that brought this other person into court. You got to dance with them at some point, right?
Well, I completely agree. I mean, from a narrative standpoint, I think it looks terrible. It just really does. It makes you think they don't want to answer for some of the things that he says. Hey, I've got a point of view on this too, and let's get that out there. Like they don't want to answer for it. Now, having said that, they're all represented, or maybe not in Smithline's case, but she was at the time this deposition was being fought over, according to her own attorney. That Manson's attorneys are trying to craft a strategy that can be successful for this whole group of cases, but they're all trying to fight him off too. And the enemy of your enemy is your friend, or whatever, that sort of thing. So fighting him here, fighting him there, it helps, I think, them generally. So the more they delay the discovery, like you said, it kind of hurts what he hoped to have for his case against Wood Gore. The longer they hold that off, I think strategically that's good for them. So it makes sense that their attorneys would want to do that, even if the women were willing to go ahead and tell their story. So I have a negative view of it, but a limit to that negative inference, because it could just be attorney strategy stuff too.
True. That's a good point. I definitely think that it gives them a very good advantage to delay these depositions as much as they can, for at least the next month or two at the very least. So to the extent that they can get like 90 days delays on these is advantageous to them for sure. So the last case that we haven't really talked about is the Jane Doe case. That's one that I really haven't focused much on, but I guess there's been some activity in it, right? I mean, have you looked into this one at all?
It's been kind of quiet. I guess part of the reason is because she's filed in an anonymous way, which they have not conceded to that, but it hasn't been really contested yet. And they actually have a protective order so the parties can make things confidential. So the only dispute I know going on right now is they're entering a discovery phase, and there's a difference of opinion between her and Manson on what can be shown to third-party witnesses that are going to be deposed, things that would identify her as the plaintiff in the case. Her attorneys don't want that identification to be connected, and Manson says it should be, and these people can be made part of the protective order if they're going to be deposed, like there's a method to protect her for this confidential information. And so they've both outlined their positions to the court. There was an informal discovery conference last month. There's a case review October 13th. I don't know that they've settled that difference yet, but to me, they weren't really that far apart. Like they weren't, this wasn't a war like over on the Bianco side. This was, well, we agree she has some concerns. We want to address them. And she's like, well, we know he has a right to discovery. We just want to protect her safety and stuff. It didn't seem like they were completely apart on this issue. So maybe don't get that out. That's all I know going on in that one.
Yeah, it's interesting to me that one was filed under a confidential name, under the Jane Doe status, which is different from all of the other ones. It's one of those things that kind of runs counter to the narrative that these women are making these allegations, sort of publicly for their own benefit in various ways. So, but I mean, there could be all kinds of reasons as to why she wants to, remain confidential, why she doesn't want her name out there. And it doesn't necessarily make her the substance of her case, the merit of her case doesn't necessarily give it support or take support away from it. But I did think that was interesting. Did you have any thoughts on any of that?
Well, I think a lot of people feel like they know who she is. I don't myself have much of an interest in that because I'm just looking at the case and that particular identity of the person, unless I knew some facts about it, doesn't matter a lot. But she has said in her discussion to the court about why her position should be the correct one for linking her into the discovery materials, that the nature of the allegation is a very private situation of sexual abuse, and then also he has crazy fans that are going to come get her if her name gets out there. And you do hear that a lot. And there are nut jobs out there on the planet, and they attach themselves to various things. That's not necessarily any party's fault. So I get where she's coming from on that. But, obviously the other plaintiffs are out in public, and they have been subjected to nasty, nasty online stuff, of course. Nobody's come to get them yet. I can understand why somebody doesn't want to have that level of abuse, whether that justifies being anonymous and for how long in the case. That's just judgment calls, but that's why she said she did it, and they haven't really pushed the court yet to revoke that. They can ask the court to revoke that, but I don't think they've pushed it too far. They just haven't conceded.
Yeah, no, those are all really good points. So did you say that you had some questions from folks that you received?
Yeah, mostly related to discovery, and the first one was is the discovery ruling in the Wood Gore case good or bad for Manson? And I think we kind of went over that. It's bad for Manson because he wanted the discovery, he didn't get it. The silver lining on that gray cloud is he's able to see the judge's thinking and where she's skeptical of his claims, and that will help him craft his opposition. So it's bad, mostly bad with a little sugarcoating around it. And then some people have asked several times, like, what about discovery compliance? Like, what if they just don't give you the bad stuff? And that's always a risk in any case, in any jurisdiction, that people will cheat, and so there can be ramifications for that. In your case, the judge, look at the Alex Jones case, whether you agree he didn't comply or not. The fact is the court exercised their authority over him for non-compliance. And those are things they can do if they think you've withheld discovery. That's an issue in the Chancery Court in Delaware with the Musk case now, saying that Musk deleted things or didn't turn things over. So it often does come up. And you want to encourage your own clients, what you do, to comply with the rules of the court, to turn over everything to you, and you do that. And I know people think every lawyer is dishonest, and they're all, it's all Goodman and stuff. But Here's the other thing. I was taught in law school, if somebody's going to jail at the end of the case, make sure it isn't you. Okay. So I wouldn't put my law license at risk to hold back a bad document for any individual client ever. It
Right.
never. So I have certainly seen in many cases, I'm sure you have too, lots of bad stuff produced by the other side. And I've had to produce bad stuff. And like in the Depp case, I thought what made him look bad was those text messages about Amber and some of the language he used. Well, they got it. They got it. And his lawyers prepped him on how to deal with it. And they made it through that. So it's a danger that things can be destroyed or not turned over. But there are other sources, third party witnesses and things where you can get emails and text messages and stuff. So I can't say it doesn't happen, but it's like perjury. People are like, well, why wasn't Amber immediately arrested and taken to jail for perjury? The system doesn't often punish it. It's hard to prove because it's a crime. So it has to be beyond reasonable doubt. And hey, it's a civil case. We got 5,000 other civil cases next week. She lost anyway. What do you care? So it does diminish faith, I think, a little bit when people perceive what they believe to be abuses of the system that aren't punished. But there is no system that's perfect. And our system does have ways to remedy that. And it's an adversary system. So if you're the aggrieved side, it's on you to bring it up to the court and show, hey, look, they destroyed this evidence and that sort of thing. Then the question was, well, what about discovery after the anti-SLAPP ruling? And if the case doesn't go up on appeal, then he would be able to get Wood's discovery likely on various issues and things like that. And the last question I got was, has anybody admitted to soliciting people on Facebook as victims? And I'm sure that's directed towards some of these accusers. Well, I don't know the answer to that. I don't think that's been an issue in any of these cases yet where someone's been asked that. So those were the questions I had.
Yeah. All right. Well, awesome. I'm glad we were able to get to that. So I think I have maybe one or two super chats here that I haven't gotten to yet. Dragon's Treasure, thanks so much for the super chats. Says support Legal Bites by going to the Dragon's Treasure, linked in description, delicious tea, and a PS5 draw. Now back to your regularly scheduled program. Thanks. Yeah, if you do, there's a link down below in the description to Dragon's Treasure. You get a discount and you get the warm fuzzy feeling of supporting this channel because I do get a little small commission from that. 2012 Jameson says, what burden does Manson have to show for the hearing? I think that he's talking about the anti-SLAPP hearing. So he basically has to show that even if the First Amendment is implicated in the allegations of the complaint, that he has a likelihood of success. He doesn't have to prove it, completely, but he basically has to show a plan, an avenue, and, some kind of evidence to support that he's got something here to actually move forward with a case. So it's like, it's not exactly like having to win on a motion for summary judgment where you have to, prove every single element. But it's not too far off from that. So I think that for me about does it. Do you have any final thoughts before we kick off?
So we hit Smithline, Bianco, Woodcore, Ashley Walters. I think we've hit all of these cases.
Yeah, I think so. Amazingly, we got through the updates for pretty much all of them, and yeah, I mean, this is gonna be a really interesting just set of cases to continue watching. Do you have any thoughts or any predictions for what we might see moving forward?
Hard to say. I mean, obviously, it looks like, I think in the main case, Manson versus Woodcore, the judge is going to strike some of it likely, and then it's going to go up on appeal, and both sides can join in being disappointed that that's going to slow it down. I think it's interesting that they haven't ruled in public on whether Ellwanger is allowed out or not. That's got to come soon. That can't hold up everything. And Walters is going to get deposed, so the cases will start to move again a little bit after they moved really fast. They hit some roadblocks from the defendants, and then they will move again unless they get up on appeal with this anti-SLAPP stuff. Yeah.
No, I think it'll be particularly interesting if any of those depositions manage to find their way to the public, like in Depp v. Heard. That is what I think a lot of people would be really looking for, is to see if there's anything interesting that actually does come up in those. But who knows if we'll ever see those. I think perhaps some of the transcript from the Ilma Gore deposition for the anti-SLAPP opposition. We may see some of that moving forward, but we'll see. I think you're absolutely right that Manson's attorneys have an opportunity to sort of change some of their strategy in their drafting of the opposition, based on what they know that the court is not exactly amenable to hearing, or what she might be more open to. So we'll see how all of that sort of works its way out. But otherwise, thanks so much for joining me here today. And you guys, for sure, if you are at all interested in the Manson cases, Steve is covering it like white on rice. So be sure to check out Southern Law. He's linked in the title and in the description of the video. So be sure to go check out his stuff, like his videos, subscribe to the channel. You'll get some really, really great insight into all of the play-by-plays in all of these cases. So otherwise, with that, I think that about does it. So I'll see you guys